Hi, today I'm going to speak on order of the speaker on 10th of January 2024 in respect of disqualification of Shinde group members and Uddhav Thackeray group member. This order was passed on 10th of January 2024 and today is 13th of January. Still, the order copy is not out in the public domain. So, whatever I recollect, I heard the honorable speaker telling at the time of passing the order. That's what my limited knowledge is. So, there is this caveat to this. And I am of the opinion that the order is perfectly right. There's absolutely no doubt. At the same time, I am of the also opinion the order is perfectly wrong. There is no dual opinion. I will make myself good why I am making this statement, which are contradictory to each other. So let's understand what is the role of speaker. Before that, let me tell you about myself. I am Girish Rao, advocate and solicitor, and this video is brought to you by Legal Scholar Academy. Legal Scholar Academy conduct various courses in law like master in drafting of agreement, master in drafting of pleading, master in RERA, and many other courses. You can get in touch within the number which are scrolling down here for those courses. And further, in addition to that, every Friday Legal Scholar Academy also conduct webinar on different topics of law which are totally free. You can get in touch with them on the number which is scrolling down here. And before we proceed further, it's my request to everyone to subscribe to this channel. And if you like this, hit a like button, press that thumbs up button to like this video. So now coming back to our topic is the disqualification proceeding by a speaker in respect of the claim and counterclaim made by Eknath Shindeji group and Uddhav Thackerayji group. So now let's first understand what is the role of speaker. Speaker plays an important role while deciding disqualification proceeding under 10th schedule of our constitution, which was amended I think in 86 or something like that by 52nd amendment, under which a member of assembly or Lok Sabha can be disqualified for leaving the party or voting or absenting from voting contrary to the direction issued by the party, or if independent member joins any political party. There are limited grounds on that. And there are certain exemption also, that if in case of merger of the party, uh, then disqualification will not be attracted, or in case of merger any member stays out of it, then also disqualification is not. So a speaker has limited role. On limited ground a person can be disqualified. Not person, a member can be disqualified from being the member of the assembly or the Lok Sabha, deciding on where it is. So as per that issue, the Speaker of Maharashtra Assembly had to decide this issue. You are all aware of how this whole thing started. Whole thing started because Eknath Shindeji group, along with few MLAs, around 30-35 MLA, went out, and thereafter they supported BJP, rather than it came out that BJP supporting them. And this started somewhere around 21st and 22nd of the June 2022. 21st of 22nd of June 2022. Since he left, the Shivsena, the remaining party of the Shivsena, which was led by Sunil Prabhu, they passed certain order or certain direction to have a meeting and all those things. And because he didn't attend the meeting, which is a party meeting, he became a disqualification. That was the case basically which they had put. So now with this issue went to Supreme Court. How it went to Supreme Court is that because then Speaker, I think Narhari Jirwal, issued, he was a deputy speaker, issued a notice to Shinde that he should file his reply by 26th 5 p.m. 26 June 2022 by 5 p.m. So taking this issue, Mr. Eknath Shinde went into Supreme Court that it's a very short period of time which is given. So what Supreme Court did was gave extended the time up to 11th of July to file a reply. And after that, governor issued a direction to chief minister to prove his majority or confidence in the house. And thereafter on 29th June 2022, Uddhav Thackeray gave resignation as the chief minister. This is what basically happened. And when the governor had issued a direction order for chief minister of then to prove his majority or confidence of the house, the Uddhav Thackeray group went into Supreme Court against that direction, which Supreme Court refused to stay that direction on 29th of June 2022. And thereafter, Uddhav Thackeray gave the resignation. This is a background, brief background. I don't want to go more, very much detail into that because I already explained it in another video. So these petitions which were pending before the Honorable Supreme Court were finally disposed of on 11th of May 2023, in which the direction was given for Speaker to decide the disqualification petition which are pending before that. By this time, there was a disqualification petition which were filed by Shinde group against the member of Uddhav Thackeray group. And Uddhav Thackeray group had already filed a disqualification petition against Shinde and other members. So there were two group of petition. One was petition was filed by Shinde group against the Uddhav Thackeray group, and there's one group of petition was Uddhav Thackeray's group against the Shinde group. There were two petitions which were before the speaker and which he was supposed to decide it. Which I am saying today also, the order of speaker can be perfectly justified based on the direction which were given by the Supreme Court. And at the same time, I am making again this contradictory statement. It's perfectly improper or wrong order. So both are correct. Only thing is that how you want to look it. And I am feeling that Supreme Court may not interfere in this order. Let's understand why I am saying so. First, I will speak why the order of the Honorable Speaker is perfectly right. So, the basis for that is the direction or the order which was given on 11th of May 2023, the final order of disposing the petition. The relevant part, which is crucial when I am discussing this, is this. The speaker, the point which is that speaker shall recognize the whip and the leader who are duly authorized by Shiv Sena political party with reference to the provision of the party constitution after conducting inquiry in this regard and in keeping with principle discussed in this judgment. So, what was directed by the Supreme Court in paragraph D of the operative part of the order is this, that Speaker shall recognize whip and the leader who are duly authorized by Shiv Sena political party. That was the direction given by the Supreme Court. Then, for us, second part also is important. Also, D of the operative part, which says that Speaker would prima facie determine who the political party is for purpose of adjudication adjudicating disqualification petition under paragraph 2.1 of the 10th schedule, where two or more faction claim to be that political party. So, what has the Supreme Court has given direction to the Speaker, which he is bound to, that to decide who is the whip and the leader of Shiv Sena political party, and prima facie determine who political party is for adjudicating disqualification petition. Here, so that Speaker had to decide this issue, who the basically the political party is. Taking this shelter, the Honorable Speaker has come to conclusion that it belongs to Eknathji Shinde group. And otherwise also he could have not gone or not come to any conclusion other than that, because already election commission had decided that issue on 17th of February 2023, that political party belongs to Eknathji Shinde group. So he could have not gone beyond that order, beyond that conclusion. If he would have gone, then it will be totally contradictory orders would have been there before the court. So he has rightly come to the conclusion. Maybe he has added more paragraph from all those things, but he has come to conclusion that, and rightly so, that this political party belongs to Sindhe. And on that basis, he has come to the conclusion that direction or the orders which were issued or whip which was issued by Shinde group was correct. The whip which I am talking about is of 2nd of July 2022. What happened is that on 2nd of July 2022, a whip was issued by Shinde Group to its member that in voting of speaker, vote should be given to the Rahul Narvekar, who is the nominee of the speaker for the speaker. And what Shiv Sena Group, that Sunil Prabhu had issued a whip that the voting should be given to Rajan Salvi, or the vote should be given to Rajan Salvi, who was the nominee of Shiv Sena Group. So there was two whip which were there on 2nd of July, which was issued. One was Shinde Group had directed that it should be given, voting should be given for Narvekar, Rahul Narvekar, who is now present Speaker of the House. And Shinde Group, and Shiv Sena Uddhav Thackeray Group had given direction that they should vote for Rajan Salvi, who was the nominee of the Shiv Sena Group. So this was the condition. Now, when Speaker come to conclusion that the voting should be came to conclusion that party belongs to Shiv Sena, Eknathji Shinde, then in that case he had come to the conclusion after that that the whip which was issued was correct and members have acted as per that whip, so they are not disqualified. So it's perfectly all right. Absolutely no doubt about his finding on the basis of that conclusion. So according to me, there is absolutely nothing wrong with the conclusion which he has come up with. Absolutely, there is nothing wrong in that order. Nothing wrong. That is the first one. There is nothing wrong. Now I say why it is absolutely wrong. It's totally wrong, contrary to the law. I will justify that also. There are two dates which are important and finding of the Supreme Court, which is important, is this. So now I'm talking that order is absolutely wrong. Now I just now discussed that whip which was issued on 2nd of July by Sunil Prabhu for voting against the election of speaker, means rather voting in favor of Rajan Salvi, that's the nominee of Shiv Sena, and which election was held on 3rd of July. And on 4th of July, there was a vote of confidence motion in favor of or against the vote of confidence motion in favor of Chief Minister, that is Eknath Shinde. So on 2nd of July, Shiv Sena Uddhav Thackeray group had given a direction not to, first is to vote for Rajan Salvi, and second is that vote against the confidence motion. So that was the prayer, that was a whip which was issued to its member. And Eknath Shinde group voted against that whip. So, so now let's see why they are disqualified. Now I am justifying why they are disqualified. Supreme Court, what? Thereafter, one thing has happened which is crucial and important. Moment on 3rd of July, the Rahul Narvekar was elected as a speaker. He recognized the Bharat Gogavle as the leader of party, or rather appointed as a whip of the party, and Eknath Shinde as a leader of the party. So when on 3rd of July, the speaker, newly appointed speaker on 3rd of July, that is the present speaker, decided that Bharat Gogavle is the Bharat Gogale is the speaker or the whip of the Eknath Shinde group. In that case, what has Supreme Court hold that? Here understand what is the Supreme Court holding. In paragraph D of the operative part, Supreme Court states that, I will read that paragraph itself. The political party and not legislature party appoints the whip, and particular manner or to abstain from voting is the issued by the political party and not the legislator party. The decision of a speaker as communicated by the deputy secretary to the Maharashtra Legislative Assembly dated 3rd of July is contrary to the law. Understand here what is saying? 3rd of July, which is in respect of recognizing the whip of the Eknath Shinde group, is contrary to the law. The speaker shall recognize whip and leader who are duly authorized by Shiv Sena political party with provision of party constitution after conducting inquiry in this regard and keeping in the mind principle discuss his judgment. So what has happened is that the Honorable Supreme Court in this part says that 3rd of July, the action of speaker is wrong of recognizing Shinde group. If that is so, in that case, how can their voting which they did on 3rd of July, that is before removing of Sunil Prabhu and his this thing, how can that be justified and not make Shinde group disqualified? as a member of assembly. They are, from this order itself, they are disqualified as a member of assembly. There cannot be even two things about it. They are, on the face of it, are disqualified. So if you see this order, and it when clearly says that on 3rd of July communication is contrary to the law, that means on 2nd of July Sunil Prabhu was the whip of the Shiv Sena, which there was one Shiv Sena at that point in time, which was led by Uddhav Thackeray, and Sunil Prabhu was rightly holding whatever the position he was holding, and he had right to do whatever he wanted to do. So he had done that. And then the claim which was made by Eknath Shinde on the Shiv Sena party was, I think, somewhere on 11th or 12th of July. Application was made before the election commission to claim that it belongs to him. So till that time, there was officially no claim on the record whereby Eknathji Shinde was saying that we are Shiv Sena, that we are Shiv Sena. No, unofficially, though it was always a case which they were saying that Shiv Sena is our, we are Shiv Sena. But officially claim was only, I think, 11th or 12th of July. So on that day, if you see on 2nd of July, there was no such claim. So 2nd of July, whatever whip which was issued by Sunil Prabhu was correct, as held by the Supreme Court. In that case, these members or the group of which are led by Eknathji Shinde was contrary to the which attract disqualification. So they are disqualified. So this order, which can be seen in a different angle, one is highly wrong and highly correct, no, proper, absolutely. So it will depend upon which way where you stand today. And when you're asking me about, if someone is asking me of the Supreme Court, what Supreme Court is going to do, according to me, Supreme Court is not going to take any decision on this issue, because it was a direction which was given by the Supreme Court for the speaker to decide, and this is some of the parameter which he has to consider. Otherwise, speaker would have not, or he doesn't have that right to enter into that domain of who the party belongs. That domain is exclusively of the election commission, and election commission had already come to that conclusion by its order on 17th of February 2023, that the party belongs to Eknathji Shinde. So in these circumstances, I don't think Supreme Court is going to give any relief to Uddhav Thackeray group. If they are expecting that Shiv Sena, or sorry, Supreme Court is going to give any relief, certainly I don't think so. And certainly no interim relief they are going to get, 100%. Court is not going to interfere at the time of interim relief. If at all they give it, at later on, but still I have my doubt. Supreme Court may not give any relief to the not Eknathji, Uddhav Thackeray group. Finally, they are not going to get relief, and the final hearing may even get postponed over a period of time, maybe by next, not next, by this August, September. By that time, the election also will start in the Maharashtra. So this is my brief thought on the order of Honorable Speaker of 10th of January. The order is not still in the public domain. On 13th, this is 13th of January 2024. So this is my opinion without copy of orders being available to general public. Thank you for listening to this. Do post your comment, what you feel about it, and I'll be happy if you have some contrary views to know that. And with this, I will take your leave. Thank you for listening it till end. Bye bye. Take care.